All right, lock in, because this sentencing hearing is about to turn into a full-on tug-of-war between tragic accident and pure negligence. We've got Mr. V. Shaw standing in court after already pleading guilty to criminally negligent homicide, a state jail felony, with no plea agreement, meaning the judge has wide room to decide the outcome. The defense comes in swinging for probation, painting this as a rare case where the defendant instantly accepted responsibility, wasn't intoxicated, wasn't on the phone, and wasn't doing anything reckless, just driving when disaster hit. But then the prosecution steps up and basically says, absolutely not. This wasn't an unavoidable tragedy. This was preventable negligence, and claims there's dashcam video contradicting key details like fog, road conditions, and whether the victim's vehicle was stopped. And just when you think it's going to stay focused on traffic facts, the state introduces immigration status, alleges illegal entry, raises alias concerns, and argues that those details matter for sentencing. Meanwhile, the judge is caught in the middle, balancing accountability, public safety, the victim's life, and what happens next if there's an immigration hold. The state wants the maximum time available. The defense wants supervision instead of incarceration. And the judge? The judge has to decide what justice actually looks like when a case is part tragedy, part responsibility, and part courtroom chess match. So here's the question for you before we even start. If someone pleads guilty immediately and shows remorse, but the state says the evidence proves it was preventable, what should matter more at sentencing?
Good morning, sir. Are you V. Shaw? Yes, ma'am. And this is cause number 25 DCCR 0507. Mr. V. Shaw was previously in court, entered a plea of guilty to the state jail felony offense of criminally negligent homicide. This was unagreed. The plea was, I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
State has, Judge.
Are there any additions or corrections to the report?
Not from us, Judge.
Not from the state.
All right, then,
So right here, we're in the part of the hearing where the judge confirms the basics. Guilty plea already entered, pre-sentence report reviewed, and no corrections. That matters because this isn't a trial. It's a sentencing hearing, and the judge is about to decide punishment based on the record, the arguments, and what the court believes is fair. Also, catch this. The plea is described as unagreed, which is huge. No deal, no promised outcome. The defense can ask for probation or deferred adjudication, but the judge is not obligated to give it. And with criminally negligent homicide, the whole legal idea is that the death resulted from a level of carelessness the law says crossed the line. Not intentional, not necessarily reckless like DUI, but still criminal because the failure to be careful was significant enough to be punishable. So when the defense is about to argue unique case, what they're really doing is trying to separate this defendant from the usual sentencing archetype. They want the court to see him as someone who made a terrible mistake, but not someone who's a continuing danger. Now let me ask you, when someone admits fault immediately, does that deserve a lighter sentence? Or does the outcome outweigh everything else?
Mr. Birch, you may proceed.
Judge, we're asking the court to consider probation. This case is unique, I would argue, for a variety of reasons. First and foremost, this court is very familiar with me and my proclivities. I would try this case 100 times out of 100. When I walked in to talk to him the first time, he said, I want to accept responsibility. That almost never happens. He didn't shirk his responsibility. He didn't, we can talk all day about the fog. We can talk about the Tex dot needs to get their act together with the shoulders on the highway, whatever we want to talk about. He wanted to take responsibility. And he said it from the first day. When was the last time you ever saw me come in and plead on the first hearing? plead guilty to a serious offense like this. Never. He wanted to do that. That was him wanting to do that. And so from that standpoint, it's a unique case. The other reason it's a unique case is there's no aggravating factors here. He's not intoxicated. He's not on his phone. He's not doing anything other than driving his vehicle. Now, what happened to these people in the end result is absolutely tragic. And again, he's taking full responsibility for that. But I will tell you, Judge, if he'd had 5 more seconds notice, he wouldn't have been able to stop the vehicle. It had 10 more seconds notice. He wouldn't have been able to stop the vehicle. He's doing the speed limit. He's driving on the highway, and there are vehicles on his left and behind him, and there is a stopped vehicle on the interstate. I mean, there's not a scenario in which maybe the injuries are less, but there's not a scenario in which this accident does not happen. And so, again, he's saying, I should have been more careful. I could have done other things. I could have fixed this. And the way he's saying that is with his plea and also his statements here. He expresses deep remorse. He struggles to sleep at night. He feels guilty about what happened to these people. And again, there's nothing redeeming about the outcome for these decedents, these victims. But the reality is, this is a situation that is a terrible, tragic accident. He is trying to take responsibility. I think that is, again, at least from my standpoint, is somewhat unique. And I'm asking the court to at least consider the distinct possibility and the option here that you have to grant him deferred adjudication probation. He would give up his driver's license. He'll give up his CDL. He'll do whatever the court orders in order to comply with probation. But putting him in the state jail for another year and a half is not going to fix anything. It's not going to make it any better for these decedents. It's not going to make it any better for their families. It's not going to do anything to anyone other than just cause him to not be out in the world for a year and a half, and that's it. And so this court could supervise him. This court could oversee his continued acceptance of responsibility and also protect the public at the same time. So we're asking the court to consider doing that. And
Okay, now the energy shifts, because the defense just framed this like a tragic, unavoidable chain of events. Speed limit, traffic boxed in, stopped vehicle, fog, no time to react. That's a story designed to earn mercy. But prosecutors don't respond to stories. They respond to elements and evidence, and the state is about to hit the court with, not an accident, negligence. And in legal terms, that's a sharp distinction. People say accident like it means nobody's at fault. But criminal negligence is literally the law saying, this didn't have to happen if you used reasonable care. And notice what the prosecutor previews: dashcam video. That's the kind of evidence that can demolish a defense narrative in one move. Because if the video shows clear conditions, hazard lights visible, and room to change lanes, it changes the entire moral weight of the case. Then there's the other layer. They're bringing in exhibits, records, background details, and later, a photo of the victim, because sentencing is also about human impact, not just mechanics. So as the state starts talking, listen for what they're really doing. They're building a case that the defense story isn't just sympathetic, it's inaccurate. Who are you believing right now? The tragic inevitability version, or the avoidable negligence version?
that is our request.
All right, thank you. Mr. Coleman?
Thank you. I'll be brief.
Are there any holds? No.
I'll be
Go
brief,
ahead.
Judge. Mr. Gertz and I agree on one thing, that I, like him, would try this case up, as he puts it, 100 out of 100 times. Myself, Judge, this is no accident. This is pure negligence, as it is a definition of negligence. I'll spare the court. I didn't of showing the court the video. The tractor trailer that this defendant was operating that day was equipped with dash cam or a version of dash cam video that shows that the vehicle that he struck was not stopped. It was traveling at a slower speed with its hazard lights on, but it wasn't stopped. There was no fog. The conditions were clear, and there was no cars on the other side of this tractor trailer rig, preventing it from even changing lanes. I have the video. The court, if it desires, can certainly watch the videos. Short clip. But Judge, I take issue with that recitation of how this all went down. I'd like to offer State's Exhibit 1. It's a certified copy of FBI records indicating that
Make
this
that
defendant.
2.
Make it 2?
Because states 1 would have been the plea papers.
All right.
And we have
That
no
will-
objection to it.
It indicates, Judge, that this defendant illegally entered this country and he's a national of the country of India. Judge, I'm not here to make some type of a political statement or commentary. I'm just simply saying that it is a violation of federal law to enter this country illegally. And Judge, like any other violation of law, in any other case, you can take that into consideration in sentencing this defendant. And I'm asking you to take that into consideration in this case, Judge. So here's States 2.
No objection. States 2 is admitted.
Judge, I also offer State's Exhibit number 3 pursuant to a business record affidavit that's been on file. It is a photo of the victim in this case, Judge. 16-year-old victim in the short
This right here is
obituary
the
of
emotional
her.
center of the entire
Yeah.
hearing.
No objection.
States
Because
3 is
once the
admitted.
state
Judge, she was
introduces
16.
the photo and mentions the victim's age, 16 years old, we're no longer talking about traffic flow or seconds of notice. We're talking about a life that ended before it even got to begin. And prosecutors do this intentionally during sentencing. They want the court to feel the gravity of the consequence, not just the technical details. The defense is arguing remorse and responsibility, but the state is reminding everyone, remorse doesn't rewind time. Also, pay attention to the language, dawn of her life, never graduating, never getting married, never doing the things people expect to do. That's not just argument. That's an attempt to frame the sentence as the only remaining tool for justice. And here's where viewers split hard. Some people believe sentencing should focus on the offender's intent and actions. Others believe the outcome should drive the punishment, because the harm is permanent either way. So I'm asking you, if the defendant didn't mean for anyone to die, but someone did, how much should intent matter once the damage is done?
16 years old, Judge. She had, at the dawn of her life, she'll never get to graduate high school, get married, do the things that people do. Judge, you can say today by your verdict just the amount of damage and harm this defendant has caused due to this negligence. I'll conclude with a couple other things, Judge. This defendant went on to continue to live his life as business as usual in California after this accident while the investigation played out. After the investigation and the indictment, it took some effort on the part of our office in conjunction with the U.S. Marshal's office to track down and locate this defendant. I'm not saying he was intentionally hiding or absconding. I'm simply saying it took a lot of effort by federal law enforcement authorities to track him down, Judge. And also this business about this name and the alias name and whether or not he goes by no name given or goes by Vishal. Again, the court can infer whatever the court wants to infer about why an individual would illegally enter this country and use at least one or maybe 2 different aliases, Judge. I'm asking for the max, and I am frustrated at the fact that all I can ask for is 2 years in this case, Judge. But I'm asking for the 2 years. In this case, I think this case warrants 2 years. Judge, if the court is not inclined to give it 2 years, I'm asking that the court deny the discretionary jail credit pursuant to my motion that I filed under Article 42A559 of the Texas Code of Criminal Procedure, Judge. And lastly, the family.
What, say what you just said again?
It's in my motion that I filed, asking that the court deny the discretionary jail credit for state jail offenses.
Oh, okay.
It's 42A559C of the Code of Criminal Procedure, Judge.
Okay.
And lastly, Your Honor, the family's here for whatever it would be, for what that's worth, Judge. And I believe that the mother, the deceased, would like to make a victim impact.
Thank you, Mr. Coleman. So it's my understanding that there is.
Now, we're in the messy intersection where state criminal court collides with federal immigration reality. The judge is basically saying, so there's an immigration hold, which means deportation is likely. And that raises a very practical question. What is the point of probation if the person might be removed from the country? The defense answers it in a very transactional way. If probation is granted, ICE has a short window to pick him up. If they don't, he's on supervision. But the defense also makes a key claim. For deportation purposes, a deferred adjudication may still count like a conviction, so the judge's choice might not change the final immigration outcome. And from the judge's viewpoint, this becomes about enforcement and public safety. Probation is built on the idea that the court can supervise you, monitor compliance, and step in if you violate. But if you might be deported, or if identity details are questionable, supervision becomes harder to justify. This is why the no-name/alias discussion matters so much. It's not just character, it's control, accountability, and whether the system can reliably track and supervise someone. So let me throw this to you. Should immigration status play any role in sentencing, or should the sentence be based strictly on the crime and evidence?
There is, at this point, immigration hold on Mr. Vishal, correct?
Yeah, that's my understanding too, Judge.
Okay. So even though it's likely for him to be deported because he's here unlawful, you're asking for probation?
Well, Judge, there's not really another option, right? So I guess the question is, given the current status of our immigration situation, I have no idea how ICE is going to handle this. What an ICE hold means is that if you give him probation, they've got 3 days to come pick him up. And if they don't come pick him up, then he's placed on probation. And what the court can then do is supervise him unless and until the federal government comes and deports him or attempts to deport him. The kind of alternative to that is he can sit and sleep on a cot that we're providing and eat food that we're providing and then be deported at the end of that. With a conviction or a deferred adjudication, he's going to get deported at some point anyway. So it doesn't really, the court, I'm not trying to be difficult, but this court's decision is not going to change the likelihood of his deportation, because a deferred will count as a conviction for deportation purposes. A conviction will count as a conviction for deportation purposes. So, again, we're asking the court for probation because of his acceptance, again, of responsibility here in this case.
All right. And I
Here it comes. The judge is about to deliver the reasoning that decides everything. And notice how the court credits the defendant for one major thing: accepting responsibility early, sparing the family a trial, and not forcing them to relive everything in testimony. That's real mitigation in sentencing terms. But then the judge draws a hard line. Probation doesn't make sense in a felony case if someone is here unlawfully, especially with concerns about identity and safety. So the judge anchors the decision on practicality and perceived risk, not just remorse. Then we get the actual sentence: 20 months in a state jail prison, less than the 2 years the prosecutor demanded, but still incarceration. And the jail credit issue matters too. The prosecutor tried to get the court to deny discretionary credit under Article 42A.559 of the Texas Code of Criminal Procedure. But the judge refuses, saying good behavior credit is handled by authorities and shouldn't be blocked as a punishment add-on. After that, the judge gives the defendant appeal paperwork and a major legal warning. Firearms and ammunition possession is prohibited after this judgment. So here's my question. Do you hear this as the judge balancing both sides, or as the judge prioritizing public safety over everything else?
And I appreciate the acceptance of responsibility. I do. I appreciate, and I'm sure the family appreciates not having to go through a trial and see what they had to live through over again. And so I will take that into consideration. Probation, to me, in a felony case, really of any kind, when someone is here unlawfully, doesn't make any sense. And again, I'm with Mr. Coleman. I'm not here to make a political statement on any of this, but if you're here unlawful and you've committed a felony offense, it just doesn't make sense that I would put somebody on probation where they're potentially still a, I don't know, threat to the safety of our citizens. And the no-name thing gives me some concern. Also, I feel like that is just potentially an attempt to avoid probably some issues with immigration and some issues with potentially this case. So what I'm going to do, again, I appreciate, and I'm sure the family appreciates, not having to go to trial. But I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of criminally negligent homicide, sentence you to a term of 20 months in the state jail prison. You will receive, I will give credit on that for any time that you've been in custody that the law gives you the right to receive. With regard to the state jail credit, I leave that up to the state jail authorities, and I'm going to deny the motion to deny that credit. That will be up to Mr. Vishal in state jail. With good behavior, he'll get that credit just like everybody else. So I'm not going to deny that. It's based on, always has been based on how you behave in the state jail prison. And so just to deny that, it goes against the nature of that rule and that law, so I'm not going to do that. I'm going to hand you the trial court certification that shows there was no agreement, which means you do have a right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that to determine what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Gertz. Good luck to you, sir. Thank you, Mr. Coleman, Mr. Gertz. Did Ms. DeLage?
Deal with the matter.
Oh, I'm sorry. Yes. If y'all will have a seat. Mr. Kimler, can you move for a second so they can use that table? You can just have a
So to wrap this case up cleanly, Mr. Vishal had already pleaded guilty to criminally negligent homicide, and because the plea was unagreed, the judge had full discretion at sentencing. The defense's entire strategy was mitigation, early acceptance of responsibility, no intoxication, no phone use, no typical aggravators, plus willingness to surrender the driver's license and CDL. Arguing incarceration wouldn't restore anything for the victims' families. But the prosecution countered with a harsher framing, calling it pure negligence, pointing to dashcam video that allegedly contradicted the defense's account, and emphasizing the human impact, especially the loss of a 16-year-old victim. Then the state added another layer: immigration records, alias concerns, and the practical argument that probation is meaningless or risky if supervision and identity are uncertain. The judge ultimately denied probation and imposed 20 months in state jail, while refusing to deny good time credit, explaining that behavior-based credit is handled through the jail system. The judge also issued appeal paperwork and firearm/admonishment warnings, underscoring the long-term consequences of a felony judgment. The broader implication is this: remorse matters, early pleas matter. But when evidence disputes the accident narrative and the court has concerns about supervision, judges tend to lean toward incarceration as the most enforceable form of accountability. And now I want to hear from you. Was 20 months fair, or should it have been probation, or the full 2 years? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Also, drop your take below, because the comments on cases like this are where the real debate happens.
Just have a seat over here and we'll go off the record for the victim impact statement.